Hi, I'm Femi OK, and you're in the stream. Justice on trial in Canada today. Why do so few sexual assault cases actually make it into the courtroom? This is a conversation, Malika Bilal, that's happening in Canada really right now as I speak. What are you seeing online? What are people sharing with you?
Well, we're actually getting answers to the question you just raised. One in particular from a man who's an advocate for sexual assault victims, and he's also the father of a daughter who was assaulted herself in 2011 in what became a high-profile case in Nova Scotia. So this is what he told the stream.
We have a situation now where victims are describing the court process as being raped again. And who would want to come forward in a situation like that? Even sexual assault crisis workers are hesitant to tell victims to report to the police because they know it's simply going to add to their trauma.
We know you want to join this conversation, and we want you to do so with hashtag AJs Dream.
So we're talking about this subject because one of Canada's most celebrated media personalities is on trial for sexual assault and choking. It's not the kind of attention that Jian Ghomeshi is used to getting. He was the popular host of the Canadian radio show Q until being fired following allegations he punched and choked former lovers. Ghomeshi says he's not guilty. Now, as he waits a verdict, the credibility of his accusers, known as witnesses in Canada, is under scrutiny in court and in the press. This celebrity case has stirred debate about how women who report sexual assault are treated. In 2014, more than 500,000 women in Canada said they experienced sexual assault, but only 21,000 cases were reported to the police and about 8,000 people were charged, a fraction of those convicted. So how can Canada's justice system better serve alleged victims while also ensuring the rights of the accused? With us to talk about this from Toronto, Jennifer-Leigh O'Neill is a sexual assault survivor and activist. Brad Burgess is a defence attorney who has represented people accused of sexual assault. David Butt is a lawyer who has prosecuted and also defended cases like these. And in London, Ontario, Canada, Bellehumeur is a former Crown or state prosecutor. So good to have you here, everybody. Jennifer-Leigh, that idea of so many people experiencing sexual assault and then so few getting to court and then so few convictions, can you explain it, bearing in mind your own experience?
Absolutely. I mean, as you said, I can only speak to my own experience. However, as a survivor, I recall the only reason that I reported to the police was because I was an educated, privileged adult who had been assaulted by a stranger in a way that was absolutely non-negotiable. Like, there was nothing gray about the abuse that I experienced. And so reporting to the police more felt like a civic duty rather than something for my own healing. Had I an ounce less privilege, an ounce less support, and had it been someone in my community, I would have never found myself in the position of coming forward.
Brad, I'm just wondering, there's so many defence attorneys out there who are spectacularly good at their job, or is the system weighted against women who say, look, I've been sexually assaulted, and the number and then the convictions, that doesn't really tally?
I don't think the system is weighted against or for anyone. I agree that there's a problem in underreporting, but once we get to the stage where the case is reported and it winds up in court, the conviction rate is over 50%, so it's coming forward, and I think that's where the real problem is.
All right, Brad, we'll come back to you. We need to sort out that audio, but we'll come back to you in just a moment. Malika, what do you have?
Well, there's another theory here from people online. This is Alper, and he addresses why he thinks that number, that discrepancy is so large. Alper says often these women knowingly or unknowingly choose to suppress what has happened to them because of the victim shaming culture. And Karen, he goes on to say, yet these women find themselves shamed anyway because they wanted to avoid victim shaming in the first place and then did not act instantly. So there's this idea online about the perfect victim, of what a victim should do. Can you explain that a little bit, Karen?
Right. Well, that's part of the problem with the rape culture and why it's so difficult for women to come forward and women to go through the criminal justice system. There are inferences that individuals and courts draw that are incorrect as far as how a woman might react to being sexually abused.
Karen, can you give us an example of that?
Sure. You know, I've encountered judges who expected a victim to immediately tell someone or, you know, act in a way that they would never speak to that person who abused them again. And that simply isn't the case. There's a lot of emotional dynamics in a relationship. And so the fact of abuse gets processed in a lot of different ways, depending on the individual, depending on the relationship. So you can't just sort of apply perfect victim conduct that you would expect, especially people apply those concepts who've never had the experience themselves.
Go ahead, Jennifer-Leigh.
I'd like to add to that and to respond to what Brad Burgess was saying earlier. To be honest with you, Brad was suggesting that there is a fair environment for complainants during the waiting for trial process and through the reporting process, and I would disagree with that with all due respect. I believe that the complainant process in Canada is somewhat comparable to psychological terrorism. You are left in the dark and you wait to be put on trial for having been sexually assaulted, from what I can tell from my experience. Survivors are people with consciences and who also want to be accountable to their country. At least I did. And for myself, waiting to go on trial was the largest liability to my trial, in that I had to wait wondering what was going to be asked of me and how my character was going to be discredited. And for anybody with a sense of dignity or self-worth, that's a hugely difficult process. And so just to respond to the idea that it's only during the trial that misogyny comes forward or that victim discrediting comes forward, I believe that the entire process is challenging. Coming forward is challenging. Having one's statement received is challenging. Police officers often do not receive statements that are put forward by complainants or potential complainants for fear that they will not be believed. So I just thought it was important to say that it is challenging for complainants throughout the process.
Brad.
Yes. And I don't disagree that it's a challenging process from start to finish. What I meant to convey was that I think that the bigger problem is getting people, victims, to come forward. And I think that, but that's not a problem that can be solved in the courtroom. You know, I feel for Jennifer in that while waiting for her trial, she felt that she was in the dark. And, you know, when I'm going to go to trial, I'm in constant contact with my client, preparing to testify and so forth. And I think that complainants, particularly in sexual assault trials, should have that same service provided to them. It may be a lack of resources on the part of the Crown, I don't know. But I agree with Jennifer that that is a huge detriment to having people come forward.
David, I want to bring you in here, David, and I hear you piping up there. I want to actually bring you in here with what some people online are talking about, and that's the process, how this happens. So I want you to have a listen to Kanwal, who talks about the cross-examination process.
I think it's really important to acknowledge the bravery of these complainants for coming out and sharing their experience with the court and recognizing how traumatic that can be. But from a legal perspective or from the defense's perspective, I think these cross-examinations are really important to test the credibility of the complainant, especially if this is about someone who can potentially be going to jail for a really long time. I think on some level it would be unfair to not allow the defense to present the evidence that they did.
So David, how do you prepare personally for a cross-examination?
Sure. Just before getting to that, I want to speak to a couple of things that Jennifer and Brad have come up with. The first notion is the idea of being in the dark, when complainants are kept in the dark. That's absolutely true, and it's deliberate. And I represent a lot of complainants as they go through the process. There's not a big enough window for complainants to have access to legal services, so I agree with Brad on that point. But just to let Jennifer and your audience know that that keeping in the dark is deliberate. So that the perception is that they don't want a witness to be tainted by knowing collateral information about the prosecution that was not within the purview of their own experience before they testify. However, you can ameliorate that feeling of isolation greatly by giving someone access to counsel with whom they can have a private conversation and
they can benefit from the assistance of preparation and greater understanding of what they're going through. So I think that there's lots of room to bring in systemic improvements that will enhance service delivery to complainants, reduce that feeling of isolation. In terms of preparing for cross-examination, I absolutely agree. Even though I represent victims for a huge part of my practice, I absolutely agree that the ability to confront one's accuser is essential to justice. And so cross-examination, appropriately constrained, I'll add, is an important tool in ferreting out the truth. So how does one prepare for that? And just basically, witnesses come to a courtroom with their humanity intact, and we are imperfect. If we are witnesses, we may have imperfections in what we observe because our opportunity to perceive may be compromised. We may have imperfections in what we recall, so our memory of the events may or may not be perfect, and we may have imperfections in how we communicate what happened, so there may be lack of clarity. Those are all fertile ground for cross-examination in every case. The fourth ground is, does the witness have credibility issues? So in other words, apart from these imperfections in perception, memory, and communication, is somebody deliberately slanting their experience one way or another? And that's another area for cross-examination. So a good cross-examination will always look at those areas. The difficult challenge is not that we get rid of cross-examination altogether, but that we keep it within bounds that are not discriminatory and do not perpetuate rape myths and do not unduly put the complainant on trial.
All right,
that's the tricky balance.
So here's what I'm thinking, Brad. You're the defense attorney. Your only job is to make sure that the person you're representing doesn't end up going to prison. So you're going to use everything in your power to stop that from happening. So what David said is incredibly reasonable, but why should you do that?
Well, I mean, you know, as a defense attorney, it is my number one obligation to look out for the best interests of my client. And I agree that cross-examination for hundreds of years has been the fastest and most direct route to the truth. And the right to cross-examine has to take paramount over a complainant's comfort level in the courtroom. Because the number one concern in a criminal courtroom is the accused's right to a fair trial and to make full answer in defense. Now, having said all of that, the criminal code, there are provisions in the criminal code that put restraints on what types of questions the defense can ask during a cross-examination. And, you know, some people may take the view that those restraints aren't broad enough. But to the extent that they aren't as broad as others would like them to be, it's a recognition of the fact that you cannot gut accused person's right to make full answer.
Do you care if you're traumatizing the witness? She's reliving that experience. Do you care, Brad?
You know,
no.
I can only speak for myself. In the course of my cross-examinations, I try to do it in a way that doesn't traumatize the complainant, because I understand how difficult a process it is. And you don't have to be demeaning or attack the complainant in order to make your point. And let's keep in mind as well that, you know, the victim is not the only person who is cross-examined in a criminal trial. A lot of these cases are he said, she said cases, and that means that the accused person also is subject to what should hopefully be a thorough and zealous cross-examination by the Crown.
Jenny-Leigh, I want to bring you back in here based on what Brad just said. There's this from Lauren on Twitter, and she says, for the defense, there is no such thing as victim's trauma because their client didn't do anything wrong. And of course, Brad already said that he's different in that respect. But she goes on to say on Twitter that a trial is about winning. Prosecutors don't even respect the trauma of victims, neither do police officers. So again and again, that person is re-traumatized. Did you feel that personally?
Absolutely. I'm still recovering from having been cross-examined about over a year ago. To be honest with you, what we deem to be relevant and what we deem to be within the realm of reason for a fair and full defense is absolutely influenced by social policy and what our citizens believe and what is status quo in terms of cultural gender norms in Canada within our justice system. And so I do not believe that being asked where the defense was in my vagina was ever a relevant question to be asked during a cross-examination, and reflects sheer misogyny within our social policy in Canada, as opposed to what the accused deserved in terms of being fairly represented. I believe that defense tactics and their interpretation of the law and what is relevant is absolutely debatable depending on who's present and who's arguing it.
You know, I think Jennifer raises some real imperfections with the criminal justice system for these kinds of offenses. I think, you know, the system doesn't need repairing for other kinds of offenses, but there's a difference when it comes to victims of sexual violence. And even Supreme Court of Canada judges have pointed out that this offense is different. And, you know, I agree with David that, you know, having some independent legal representation is one way to improve this system. You know, there is no solicitor-client privilege between a Crown and a complainant who's getting prepared to testify. And there's reason for that. If a complainant says something that they haven't said before, it's got to be disclosed to the defense counsel. So, you know, having someone that could support a victim and prepare them in a way that Crowns can't, I think would improve the system. You know, there's some issues with the system that, even if the Crowns have best intentions, which they generally do, and every Crown tries to, you know, do their best for the interest of the victim, their primary duty is to the public and the best interests of the public. And so, you know, the fact that a victim is not a party to the proceeding, but is only a witness, is really an area where the playing field is not even. And you know, there has to be a better way to address that problem.
Karen,
I'd like to echo that.
Yeah, go ahead, David.
Add this. Karen's absolutely right that Crown attorneys, they're dedicated public servants by and large, doing a wonderful job, but they do not act for victims, and they will be the first one to tell the victim that. And then you have this bizarre situation from the complainant or victim's perspective where she's
David,
saying, hang on
hold
a
tight for a
minute.
minute. So the Crown attorney is not working on the victim's behalf. Whose behalf are they working on?
They're working on behalf of this idealized, abstract notion of justice. So they are called impartial ministers of justice in Canadian jargon, which means they act for this ideal of justice, which certainly takes a complainant's perspective into account, but also takes the accused perspective into account, the community's perspective, the court's perspective. Whoa. So it's a very broad and abstract role. It is not to represent the complainant. And so invariably, she goes into a criminal prosecution going, hang on a minute, the public has a representative, the accused has a representative. This is all about my experience, and I have nobody representing me. It's confounding and alienating, isolating, and it needs to be fixed.
I mean, there's some fixing that went on, and that's back in 1992 when there was the Rape Shield law that came into Canada. How is that working out? That means that you can't take into account an alleged victim's background, her sexual background. Any of those details are not supposed to come into the court case. Is that helpful?
Yes, it is helpful in the limited sphere that it operates. In many cases now it puts a victim's prior sexual history off limits. You of course can apply, and there are exceptions that do allow you to get into it. But that doesn't eliminate a terribly broad area. If it's open season on complainants and they don't have lawyers to stand up for them, good defense counsel will always work around that and find other areas to engage in the same aggressive attack methods that re-traumatize complainants.
I completely agree with this.
Yeah, and I think that after the abuse conduct is one of the problems now, more than previous sexual history. Now, you know, we saw in the Ghomeshi case, the post-abuse conduct is being used to draw inferences in a way that's harmful to victims that aren't necessarily true.
But also in terms of, you know, post-incident conduct, you've got situations where, you know, witness says one thing on the stand, you know, I took steps to avoid him after this happened, and then is confronted with, evidence to the contrary. That simply is not true. And I think that far from being offside, I mean, that's the whole point of cross-examination.
Let me just share that a little bit with you. This comes from CBC News. So if you've not been following this case very closely, this little clip here will explain what Brad was just alluding to.
The complainant said when she'd given her statement to the police that she was nervous, that she sometimes spoke too quickly and maybe not as thoughtfully as she might have. When the defense suggested that this might in fact be a lie as opposed to nervousness, the complainant said, "I told them the truth." Hannon says, "And your truth, you'd agree with me, keeps changing." The complainant, "I wouldn't agree with that. These are memories I'm recalling."
You know, moving this forward, Femi, one of the things people online are talking about is what justice would look like for them. And so we got this tweet from Danya. Jenny-Leigh, I'll direct it to you. She says, "What we need to do is review and revise our criminal system to include a trauma-informed process. Compassion and lawyering aren't mutually exclusive." How would you see that happening?
I would completely agree with that statement. And the way I see that happening is, well, first and foremost, I'm not the entire expert on this. I'm not a lawyer. I'm not a judge. I'm not a defense lawyer. I'm not a crown. However, I do believe that in junction with our criminal justice process, increasing the use of our restorative process could be of value to not only uncovering the communicative process that does result in abuse, not saying it's the survivor's fault, but to inform the criminal process through a restorative process, we could possibly uncover elements of trauma that impact memory and the way that complainants treat perps after abuse. As in, it's quite logical from some perspectives to keep in touch with your perp afterwards in order to A, make sure you know where they are, and B, make sure that they're happy with you so that they don't do it again. And so I think that using expert witnesses and a restorative process in junction with our criminal process could be of value to making a more full and fair discussion, as David Butt once said.
We've got three great legal minds on the show, and I just wanted to pick your brain here. We're right at the very end of the show, but this Jian Ghomeshi trial, what do you think the impact might be on the judicial system in Canada? Any at all? Brad, just briefly. I'm going to go through Brad and David and Karen. What's your thoughts here?
Well, I don't know what sort of impact it will have on the criminal justice system in this country. What it will do and what it has done is spurred conversations like this. And I think that's crucial because the more information that complainants have, that victims have who haven't come forward, the more information that they have, the more empowered they feel, I think the better. So that's the effect that I think the trial will have, and I hope that it has.
David, your takeaway?
Yes, in the short term, it's going to have a profoundly negative impact because I think the community of complainants across the country will look at the hell that those complainants have gone through and will run straight the other way. I hope, therefore, that those with responsibility for the levers of power in the justice system will recognize that we put on a terrible show for the victim community and that we have to step up our game, introduce meaningful reforms that will integrate complainants fairly but more comprehensively into the process. So I think it's an excellent opportunity to have that conversation.
Sure, Karen, just very briefly.
Yes, and I agree. I think it's going to cause a chill and it's going to really interfere with people's access to justice. And that's a human right, access to justice. And so I think we do need alternatives. I think we have to look at the civil process and ways that victims are more comfortable with coming forward. There's lots of ideas out there. The civil process can be attractive because it doesn't attract jail sentences. It's more to do with monetary compensation. And as Jennifer said, you know, that relationship may require a less penalty to really bring forward victims.
So Karen and David and Brad and Jennifer-Leigh, thank you very much for your thoughts, your insights. We are taking you to our online post show, stream.outerzero.com. Hopefully our audience can join us there as well. Thanks for watching, everybody. Hello there, I'm Femi OK. This is the online post show where we've been talking about sexual assault cases in Canada and why so few of them make it through to court and then conviction. So just coming back to you, Jennifer-Leigh, you've been actually at the Jian Ghomeshi trial out there following it. Why?
Well, from my own experience, I recall feeling very alone while I was in the victim witness identity. Victim witnesses are not allowed to speak on their own behalf publicly for fear of discrediting themselves on the stand. And so when I see such excessive coverage of Ghomeshi's defense team and Ghomeshi, I feel like it's important to visibly show a face that says we do not believe this perspective and that survivors believe survivors. We're here. We've been through it. We know what this is about, and this is not an honest process.
See, Brad, almost this conversation feels very weighted towards the alleged victim, but there's also, I mean, there are two parties in any trial, so then you're looking at the defendant as well, and there will be cases where the defendant isn't guilty. So do you feel that the focus is in the wrong place or the right place right now with this conversation?
Well, I mean, I think the focus is in the right place. Even though I'm a defense lawyer, I don't disagree that the system is unfriendly to complainants, and that has to change. But you raise a good point. There are false allegations of sexual assault that come before trial judges. And, you know, our system is designed so that it's better that, 10 guilty people walk than one innocent person goes to jail. And that is as it should be. So
it's better that 10 guilty people. See, Brad, so you'd rather 10 people who either sexually assaulted or maybe raped women went out, rather than one person who didn't do it went to prison. I mean, that's an awful situation to be in, really, isn't it? I mean, isn't that a lose-lose situation?
I think it's. I think we're aspiring in absolutely the wrong direction. That's certainly the mantra that gets stated, better that 100 people go free than one innocent be convicted. Yeah. Frankly, I think the only acceptable ideal to aspire to is that no innocent person gets convicted and no guilty person gets acquitted. And until we adjust our thinking and focus on that zero error rate as the ideal to which we're all aspiring, we are going to err on the side of disserving complainants in the process.
I would completely agree with that. Just to jump in here, to be honest with you, if anybody in this room or in this conversation were to go through the process of a sexual assault trial, I think it would become very clear that no victim witness would do this for the purposes of discrediting another person unless they were sociopathic. The rates of false allegations for sexual assault actually exist at a far lower level than most crimes in Canada, including break-in entry, including murder, including fraud. And so I find it upsetting when I hear the argument used that there are false allegations as a means of such rugged interrogation, because to be quite frank, this process is horrible and no individual would make it to the end of it if they were lying unless they were actually a sociopath.
Right, and that's why this is not the appropriate system to deal with this societal scourge. The test is whether the case can be proved beyond a reasonable doubt. So defense only needs raise a reasonable doubt. I've had judges say to me for a jury address, the function of the jury is not a truth seeker. It's just to simply determine if there's a reasonable doubt. So this adversarial dual party system is not an ideal place to ensure that every guilty person is found guilty, every innocent person is acquitted. The system needs reform to assist victims. Otherwise, we're going to continue with very, very low rates of reporting.
Karen, it's interesting that you mentioned the process of the judge, and that's actually, I think a few people have tweeted in about needing reform. This is just one of those tweets. This is Ruba, and she says, victim blaming continues, and she gives this example of a judge recently telling a rape victim that she should have kept her knees together, and it wasn't actually that recent. It was a couple years ago, but the case just came out. Femi, I know you have more information about that.
Yeah, have a look here on my laptop so you can see this is a story here on CBC News. So Robin Camp, federal court judge, faces inquiry after berating sexual assault complainant. This is what he said. Why couldn't you just keep your knees together, and why didn't you just sink your bottom down into the basin so he couldn't penetrate you?
And I'd like to...
Yeah, go on, Jennifer-Leigh.
I feel it's important to point out also that the alleged or the accused or the found guilty in this situation was approximately 100 pounds larger in size than the complainant. And so this judge, and I do believe this judge also referred to the complainant as the accused throughout the trial, from what I understand.
Clearly that judge...
It points to an important opening in terms of reform. In Canada, we've developed specialized domestic violence courts, we've developed specialized mental health courts, and we've developed specialized drug courts that recognize the unique dynamics in which those crimes get committed. I think it's worth seriously discussing specialized sexual assault courts so that we can have a judiciary and we can have counsel appearing there regularly who are not buying into rape myths, who are not blaming victims, who are not insensitive to the potential for re-traumatization. And if you have those kinds of specialized courts, I think you can go a long way towards addressing some of these problems, because I absolutely agree with Brad that we cannot compromise proof beyond a reasonable doubt and access to a full defense for accused persons. But the specialized court seems a way to try to integrate those sometimes competing values.
Karen, do you think that's realistic? Do you think that's realistic?
So, I don't think it's going to solve all the problems, no. We've had some great law reforms in the 80s and 90s. We had, the rape shield law. We had preventing getting psychiatric records as into evidence in many cases. But it hasn't affected the rates of reporting. It hasn't affected the rates of sexual violence occurring in Canada. So I think something more radical is necessary. I think it's helpful to try to reform the system as much as possible. More training is necessary. I mean, applying the actual law on consent is important, and I don't think that happened in the case that you just referred to. But a parallel system is something that I think warrants some investigation. A system, as I said, that doesn't rely on all the problems that the criminal justice system has encountered over many, many years.
I actually agree with Karen on the parallel system as well. It provides a menu of options for complainants. If we had a state-run system of civil proceedings, we would get rid of proof beyond a reasonable doubt. The accused would not be convicted, would not have a criminal record, but would be held accountable by a court. And by the way, it would be answerable in court, unlike a criminal case where they can invoke the right to remain silent. So a menu of options, I think, reform our criminal justice system, offer those real alternatives, and certainly look at the more reconciliatory approaches that Jennifer's been talking about as well. I think we need a real menu of options if we're going to accomplish effective change that will bring the non-reporters into the system.
And what I think is important to recognize is that in an era of and that's a really good point, but in an era of neoliberalism, privatizing our court systems so that complainants are necessitated to find their own defense, pay for their own defense, and initiate their own cases is perhaps not recognizing the privilege that goes along with the capacity to report as a complainant. Furthermore, I think it's important to keep in mind that we do have a restorative process that can be used in junction with our criminal process, however is underrepresented, understated, and underused. And so a restorative process that would turn the he said versus she said into a we said what happened would perhaps help complainants in the longer run to understand what's happened to them and help perps learn how to respect the laws of consent.
Thank you so much, everybody. I really appreciate your time today. Karen and David and Brad and Jennifer-Leigh, thanks for your insight. We could have a whole different conversation once we hear the verdict, but we'll leave that one for another day. Appreciate your time on the stream. Take care, everybody.